Hello friends, welcome to the YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss the decision of a writ petition decided by the Rajasthan High Court. The name of the case is URMILA versus Income Tax Officer and the matter has been reported in 446 ITR at page number 511 and the date of the judgment is 28th June 2022. On section 148, I was not making videos since a long time because in every case, whenever the writ petition was filed, the cases have been reverted back to the AO just to reconsider them. In none of the case, I have seen that the notice under section 148 has been quashed. Very few cases are there which have been quashed. Only 5 or 6 you can say in the whole India. And in all those cases, the assessing officers were making mistakes like nothing. But the courts are very generous to them. Every time they are giving second opportunity to play or the second innings to play. No balls are allowed to them. They can say that whatever the bowling has been done by the assessee is no ball and they cannot be run out or they cannot be out. Even if they are out, they can play any number of the innings. I feel like that. But in this particular case, the assessee was very much apprehended because the assessee deposited the cash of near about 34,01,000, but the assessee received a notice of income escaping assessment just of the double amount of whatever the cash has been deposited by the assessee. That is, the notice was saying that income escaping assessment is 68,02,000. It is the point of the assessee that just to cover up the limit of 149, that is 50 lakhs, the department has doubled the amount. That's why the assessee reached to the High Court. But the High Court said that we cannot examine the facts. We cannot go into the integrity of that, how much cash has been deposited by the assessee or not, whether this amount is just double or not. But the High Court refused to interfere into the matter, and the High Court said that this thing you can explain when the assessment proceedings will be going on under section 148. No doubt that in the order, the Rajasthan High Court said that this fact should be examined by the assessing officer. But the notice was not quashed. It was not remanded back to the AO just to reconsider that whether the amount is 34,01,000 or 68,02,000. Because if the amount will be 34,01,000, then in this particular case, the notice will be out of the section 149 limitation. But the department was given a gift by the court that and the assessee was directed to appear before the assessing officer in section 148 proceedings. So there was limitation on the High Court because the High Court cannot examine the facts. The Honorable High Court does not have the time to examine the facts. But this situation is good. In that case, where the assessing officers or the assessing authorities are really considering the submissions of the assessee. But in this era of faceless, whatever the submissions, whatever the facts which we are bringing to the assessing authorities, they are just neglecting them. They are just not considering them. They are just making fool of the assessee, and whatever the submission we are giving, they are just saying that we have considered and those are not tenable. In this particular case, the writ of the assessee was dismissed with the direction that whenever the assessment proceedings will be going on, the AO has to consider whether the amount is just doubled or not. But the matter was not reverted back to the AO. In this case, one more thing was there. 7 days time was given to the assessee. Assessee asked for adjournment. And on this ground also, the assessee was saying that my adjournment application was not considered. Hence, the principle of natural justice has been violated. So, on this point, the court said that you have not shown the extraordinary circumstances that why the adjournment should be given to you. It means that whenever the assessee is seeking adjournment, the assessee has to show some very genuine reasons that why the assessee needs adjournment. Now, it will not be given as a matter of right that if I will seek the adjournment and the adjournment will not be given, then I will say that the principle of natural justice has been avoided. Even if the court said that the assessing officer even didn't mention in the order under section 148A clause D that the assessee has seek the adjournment and he has not given the adjournment. So if it is the point of the court that the assessee has to show the extraordinary circumstances to seek the adjournment, at least the AO should also be directed that they should mention in their order that why they have not considered this adjournment. At least they should say in the order that the assessee has not shown the extraordinary circumstances. That's why we are rejecting the adjournment application. But nowadays, only the assessee is overburdened with all the legal formalities, all the legal compliances, and even in the slightest mistakes, the assessee has to bear a lot of cost in the form of high-pitch assessments, then demands, then you have to face your attachment of accounts, attachment of properties and all that blah blah. So this is a very difficult time for the assessee as far as the income tax proceedings are concerned. At the end of this video, once again I am repeating the name of the case. The name of the case is URMILA versus Income Tax Officer. Thank you, friends.